Welcome to another episode of Image Rights by N. Mashinini, the only podcast dedicated to image rights in Africa and around the globe. Today we are joined by Nathan Ross Adams. Nathan, how are you?
I'm doing really well, thanks. How are you?
I'm fine, thank you. I'd just like to introduce Nathan quickly for our listeners. I really find this bio very interesting. I'm excited to have Nathan here. So Nathan Ross Adams is an Afrofuturistic transactional lawyer from Cape Town, South Africa. At Michelson's Attorneys, he practices IT law and advises on the contractual, data protection, and information security aspects of emerging technologies. He's also a keen researcher on how AI and blockchain technologies are disrupting company and contract law. However, his interests extend to robotics, drones, Internet of Things, data science, biometrics, cloud computing and cyber security, nanotechnology and neurotechnology, digital precision medicine, as well as space law. Currently, he's finalizing his Masters of Law thesis at the University of Western Cape on South African company law in the Fourth Industrial Revolution. Does artificial intelligence create a need for legal reform? Next, he's preparing for a read for an LLD focusing on the intersection between company law, AI, and blockchain. Wow, that's a really interesting bio. Thank you so much for joining us, Nathan. You know, I've been following you for some time now on LinkedIn, and I've always found it interesting how you keep us up to date with the technology law issues around the country and also around the globe, actually. I actually look forward to seeing one of your posts every time I log into LinkedIn. I think sometimes you're the only reason why I go onto LinkedIn.
Thanks so much.
So, Nathan, we've seen a lot of regulatory developments in the data protection and cybersecurity space lately, not just in South Africa, but around the world as well. A lot of African countries are also starting to develop data protection and cybersecurity laws. We know about how the EU has also been challenging social media platforms under the GDPR regulation and all of that. And what I also find interesting is that with the rise of these regulatory rules around data protection and cybersecurity, we also have an equal rise of deepfake technology, which comes with all sorts of interesting and very disturbing developments. And one of the things that I wanted us to talk about today is my concern around nudifier apps. And so the first question I have for today for our listeners is, what are nudifier apps? Can you start off with that?
Okay, perfect. Thank you very much. So nudifier apps is how deepfake technology actually manifests in a physical form, or so in the form of a website application or a mobile application. If you think about deepfake technology, it's in essence, it's a type of AI learning technique based on deep learning, and it's actually used to create synthetic media, so in the form of images or videos. And what these apps actually do is they facilitate the deepfake technology so that it can actually produce the result that a specific app user or website user would like to achieve.
Wow. So I've been reading a number of articles talking about how nudifier apps can help someone see you naked or something like that. And I've actually wondered, how true and how accurate is this?
Well, there've been a number of articles out there about specific nudifier apps. So the most prevalent one is Deep Nude, which has appeared all over media. And what it specifically does is it would take an image or video of someone and actually, one that was actually taken by that person. And then what it would do is superimpose pornography on that person's person. So it's been a matter of big debate internationally because one of the biggest challenges is that although we have laws that deal with these different types of cyber crimes and data protection laws, they are very slow to catch up to what's actually happening from a technological perspective.
Wow, so you mentioned that we do have some laws that address these kinds of applications. So from a South African perspective, can you describe the regulatory framework that would apply to the use and the creation of such applications?
Yes, definitely. Thank you very much. So I would think about this from someone who's actually, from the perspective of someone who's actually been a victim of this technology, uh, because, well, a victim or complainant, and I would generally take 2 or 3 approaches at least with this. So the first approach is a civil approach, the second is a criminal approach, and the last one is a general corporate governance approach, and I'll explain that a bit later. But basically, the civil approach is for you to rely on the Protection of Personal Information Act, the POPI Act, which everyone should be familiar with right now because it's been all over the media and the information regulator has been pushing that message. But basically, POPIA deals with the rights of data subjects, and those are anyone, could be a person or a company, and it deals with any type of personal information that relates to that person or company. And when it comes to deepfake technology and nudifier apps, that image of a person would be classified as their personal information. And depending on the type of image as well, it could be a biometric photo, like someone's passport photo, or which deserves more protection. But essentially, under POPIA, data subjects have a right to access their information, and it's one of the common principles of data protection across the globe. And what they can actually do is something called a data subject access request. And that is where they would approach a company. So say a company has developed a nudifier app, or they developed an app that could do deepfake technology. They would approach the company and say, there's this image of me, it's my personal information. I have the right to access it and request that you remove it from your database. So that's it's a civil approach that can be taken. When it comes to the criminal approach, just before I go to the criminal approach. So, and if that company does not comply with your data subject access request, then you would complain to the information regulator about that. They have a specific email address where you would address your complaint to them. But when it comes to the criminal element, we have the Cybercrimes Act in South Africa, which was recently enacted, but it's not enforced yet. The South African government still needs to announce when it comes into action. And essentially, the regulatory body over there is SAP, so the South African Police Service. And under section 16 specifically, it deals with the disclosure of intimate imagery. And in that section, what it specifically deals with is it prohibits and makes it a crime to actually distribute or on a system any intimate image of any person, so regardless of their sexual orientation, their gender identity, and one of the pertinent facts about it, it doesn't matter if it's real or simulated. And based on that interpretation or the wording in the act, it could apply to deepfake technology as well, and nudifier apps, because they are simulated images or videos of people. So and this ties in with the general theme of revenge porn, which is very prominent across the world at the moment, and how it's regulated. So in that way, our Cybercrimes Act is pretty advanced and technology neutral. You can call it that way because it provides for any type of technology. And then in the Cybercrimes Act, there are 2 other provisions which may help out, and that's Section 9, which deals with cyber forgery, and Section 10, which deals with cyber extortion. So where someone someone extorts someone creating deepfake technology and then reporting on it, or not reporting it, contacting the person saying, if you don't give me a certain sum of money, I will publish this deepfake of yours. And so in that instance, that event amounts to cybercrime as well. But just lastly would be one of the clear separations would need to be or not clear separations, but considerations would need to be, if there are children or minors involved in this, the Children's Act automatically becomes applicable. So does the Film and Publications Act when it relates to child pornography. So the regulatory model is pretty widespread in that case. And then lastly, from a corporate governance point of view, if you were a company that wanted to comply with our King Code, which is our corporate governance law, and international best practices on corporate governance, it would be very difficult to motivate why you need an app that can create nudes of people. So you could argue that it goes against the IT governance principles of King 4. And just from a general compliance perspective and reputation management, if you have created the app that enables certain behavior, you can't remove yourself. Well, you shouldn't be able to remove yourself from the end result. Yeah, but that's it in a nutshell, the regulatory landscape.
You know, it's interesting that you point out we have this broad regulatory framework, right? But one of the concerns I usually have, especially when it comes to um, notices that you can give to a company or a developer of such an application, is how quickly they would respond and whether they would respond in a favorable manner. I know in the past when we still had only the Electronic and Communications Transactions Act, before POPI came, before the Cyber Crimes Act came, we would always find it problematic how takedown notices are really honored by a lot of these platforms, internet service providers, and so forth. And so I wonder, how effective would this kind of notice procedure be under the Protection of Personal Information Act? Are we expecting that anything will change compared to how we saw things play out with ECTA now that we have POPI? Or is it that maybe POPIA has much more stringent penalties that could maybe encourage companies to come forward and actually honor such takedown notices?
That's an excellent question. And I think the answer that I would lean towards is the difference between ECTA and POPIA is that we have an information regulator backing it, well, an active information regulator who's keen to be involved. And one of the things that I find really interesting, or the setups at least, is that our information regulator is responsible for personal information, but also access to information. And if there are specific legal techniques that lawyers can use, like the data subject access requests, which I mentioned, or if that doesn't work, there's also, or not doesn't work, if that option isn't the best, there's, from a strategic perspective, there's also the PIO requests, or the promotion of access to information requests, which aren't often used for this reason. And that the PIO request is specifically where an organization, you can access your, well, information from an organization to enforce one of your rights. And so there are a lot of strategies that can be used when it comes to general organizations. The trouble, though, is when it comes to big tech. Yeah. So when you have companies like Twitter, Facebook, and someone posts something that maybe deepfake technology that, or deepfake pornography, Facebook's algorithms would generally cancel it out. But if it doesn't, what would need to happen is you need to lay a complaint, you need to report the posts, and it's a pretty long process. The same with Twitter. And it essentially, from my perspective, we need more sympathy for the victims of these instances, because something traumatic has already happened to them. They've been exposed on some sort of social media. SAPS is catching up from a cyber criminal perspective, because they are still getting investment in the technology. So I'm hopeful that things will change, but I'm not sure if they'll change immediately, because there's still a big gap from a government perspective when it comes to having the actual skilled people and skilled investigators to invest cyber crimes like these.
So would you say that we're seeing a sort of a technological angle to this gender-based violence problem that we have already in South Africa? Because I'm thinking that the majority of victims of these kinds of acts would be women and children.
Yes, definitely. And I think one of the things that the government hasn't spent enough time on, and I wish they would, is so we have a new Minister of Communications and Digital Technologies, and she's brilliant in her background. She's one of the ministers who's actually worked in the tech industry, so she has a full understanding of how it works. I think there needs to be a cross-department communication about how to deal with gender-based violence in a way that's not only focused on training police officers and the front runners, but also training the investigators that actually need to go out there and interact with what has actually happened. I mean, GBV is a real issue, but we have social media that could actually not only raise awareness, but stop things in their tracks. So before they get worse. In the same way that algorithms can be used for bad, they can be used for good, and this is one of the ways that they can be used for good. But when it comes to how it's currently being used, I think we have so much room for progress.
Yeah, thanks for that. I think we do have a lot of room for progress, and I think we urgently need to work on this gender-based violence issue. Now, you've mentioned POPIA, the Cyber Crimes Act, and corporate governance, right? So when I'm looking at all of these, I'm thinking, okay, how do we impute liability and to whom, really? Because I'm looking at it from the perspective of the victim. With POPIA, they can surely go after the company that is in charge of the platform or the technology that is being used to perpetrate these crimes against them. With the Cyber Security or the Cyber Crimes Act, rather, I'm seeing that this would be targeted at the user of the app or something like that. So can you just take us through that? Who do we impute liability to and on what basis?
Makes sense. So just before I get into the detail of where liability can lie, I think one of the biggest challenges with coding and app developing generally for artificial intelligence and deepfakes is that there's no ethical standard that coders and companies actually need to follow when it comes to their coding and how they develop apps, and that creates a big problem because or maybe I should put it differently. I understand that from an ethical hacking point of view, you would want to be able to create code that could ethically hack a system and test it to see if cyber criminals can attack it.
Sure.
But when it comes to deepfake pornography, things become more complex. You would need to, I think my perspective is that you would need to have regulation in place that says, if you develop an app that has an outcome of creating a non-consensual deepfake technology, then it needs to be subject to a regulation. And I'm not sure who should be responsible for this, but it's basically about having an ethical standard and guideline for code. There are some, you can look at something similar to the ISO standards, international ISO standards, or King Code. Those are examples of soft laws, but what we need is a combination of soft and hard laws, like the Cyber Crimes Act and POPIA. But when it comes to liability, it becomes challenging because with POPIA, the only liability that the company will have is if it doesn't comply with the POPIA Act and respond to the victim, they will get an enforcement notice from the information regulator and maybe be fined for what they haven't done. But they can still appeal that through the courts, the regulator's decision through the courts. So there's no real civil liability over there for the victim, unless there's some sort of other civil claim which they can argue from a constitutional perspective that the human dignity has been implicated or something. But that's not specific enough. There's no legal certainty there. But when it comes to cyber crimes, again, it's tough because an organization isn't going to be held liable criminally for what has been done, or its directors won't be held liable criminally, but the person who actually used the app to create the image or video could be held liable if they can be traced. And this is one of the challenging things. We have virtual private networks. We have anonymous signups to apps. We have so many things that prevent the end users of apps from being identified. And that makes sense from a privacy perspective. And if you're an investigative journalist in a country whose laws are very strict on access to information, then that makes sense. But when it comes to someone using an app for an unauthorized person, for an unauthorized purpose rather, that person needs to be held liable for that. Otherwise, the victim is left without any recourse. But that's difficult in itself. But when it comes to the organization, that's my biggest concern, because there's been a case in I think it's in the EU about 2 or 3 years ago, where it dealt with Google and Google search engine, and the question was whether Google could be liable for what its search engine produces and the answers it produces if that answer violates criminal or civil law. And what Google argued was that because they created the deep learning and artificial intelligence, that they can't be responsible for what it produces. And the reason behind that is because the basis was that AI is black box technology. You can't see what's happening and you can't see how it reasons. And that's the approach most companies are taking right now, most AI companies. If you look at their terms and conditions on their website, they disclaim liability for any unauthorized use of their platforms, because they could argue that they didn't create it for that purpose. So in essence, there's a lot of uncertainty when it comes to liability. There's not much recourse from a civil or criminal perspective for the victim, or nothing tangible yet. I'm not saying that money can actually can solve the problem of someone's images being manipulated, but it would be something that would help and be an end, or something tangible that someone can see. But yeah, it's a tough one.
Wow. And are there no grounds on strict liability principles, perhaps?
It really depends on the contractual relationship between the company and its user. So a company can, for example, have an acceptable use of IT policy, or an acceptable use of the platform policy. And in there, they can say, if you use the app for illegal purposes, we can remove you from that. But the company itself can't hold someone criminally liable. That's up to SAPS. Yeah.
This is a complex situation. It's a sticky situation. Because I tend to be concerned about people who download apps, use them, not knowing the legal implications of how the use can put them in hot water, particularly when you think about how image rights are exploited on social media these days. I've seen that monetization of content is very popular nowadays, which from my research background, it gives me this impression that, well, then if you're going to make money off of using other people's images without permission, and also in this revenge porn context and this nudifier and all of these kinds of apps, then we're having a much more deep-seated problem of image rights and privacy in basically one box. Because to make money off of someone else's image, it is unlawful in certain contexts, especially when there's no permission to make money off of someone's image. And now it's trickling over into this whole cybercrime space. And I wonder when we are going to actually get a date of commencement for this act. I am sitting on the edge of my seat. Yeah. So so with children, you mentioned bringing in the Children's Act, right? And I wonder, even with the Films and Publications Act, how effective has the Films and Publications Act and the Children's Act been already in addressing particularly gender-based violence issues against children, or even in the space of how I know people have these dark websites where they go on for child pornography and all of that. How has that been effective so far when we look at the Children's Act and the Films and Publications Act?
So I'm not sure of the stats when it comes to the Children's Act and Films and Publications Act, but what I know is that it's from a South African perspective, at least, we've had we've had not as many reported cases as other jurisdictions. And the reason for that is because or at least my perspective on that is that not enough cases are being reported. So like in the instances of GBV, when you have cases of rape, there are the amount of cases that are actually reported are cursory compared to what actually happens. And the only time it actually comes forward is where the media publishes a big story about it, and then everybody is aware of this for like and trends on social media for a week or two, and then people forget about it. But when it comes to the Film and Publications Act, I know the board itself has been having a lot of issues for being back, outdated with this perspective. A lot of academic writers have argued that the act actually needs to be updated to deal with the new types of technology, because an image wouldn't be classified as wouldn't be subject to film and publication reviews, for example, but video content would. And the question is, does that extend to virtual content, virtual reality, which is created with these with deepfake technology? So, in short, I'd say that I've not heard of many cases being reported. I've only followed what's been shown in the media. There are opportunities to use these acts in ways that can support children's rights, but again, another point is that there aren't many lawyers who are doing the crossover, and this brings me to my last point on this, that we need academics and lawyers and people in the legal industry who are not only focusing on one branch of law. So, for example, copyright law, company law. There's the law areas, technologies are making the areas of law overlap, that we need to have an understanding of 3 areas of laws, for example, copyrights, contracts, and say company law, and then adopt that approach to actually looking at the same with criminal law. You need criminal law and internet law and evidence law if you want to have a proper perspective on these things. And only through lawyers actually playing their role in understanding the complexity of the legal landscape can actually use it strategically to enforce these rights. But again, that's only the role of lawyers. You also need implementation from government side. We need more policy as well.
Wow. There's a question that I want to quickly just throw in here from a lot of people who have asked me about these issues, especially with deepfake technology. And this will be my last question, I promise. So when you think about things like deepfake, where someone's face is maybe superimposed on a pornographic video, or vice versa, you often find that there's more than one person's bodily features that are involved in the development of an image or that particular deepfake video. And so the question that really usually comes up is then, who's the victim? Here, for example, if you look at it through the lens of Section 16 of the Cybercrimes Act that deals with malicious content, who's the actual victim? Is it the person whose body is shown in a very sexually posed manner, or is it the person's face, who becomes the victim in the context of Section 16, for example? Because I think the challenge that we often have with these kinds of situations is that on the face of it, there's more than one victim, but who really has a tangible claim when it comes to this kind of an issue, or a tangible complaint when you're dealing with the Cybercrimes Act?
Yeah, so this is a challenging one, but the way we've approached it is to actually look at, to separate where are the elements where an image was used with consent. So someone actually consented to their image being used for pornography. In that case, there wouldn't be an issue. But if that image of that person who gave consent was superimposed with, if that consent was given for publishing pornography, but that picture was rather taken and superimposed with another image, that consent may have stopped before that act happened, and then it would be a complex bundle of rights. And so you would need to separate those rights and look at, okay, we can have 4 victims because there were 4 images taken of people. one of the important instances in Section 16 is that they say that the Act says that the person doesn't need to be identifiable in there. So the person's face doesn't need to be identified in there. It could just be a part of the person's body that could be reflected in the deepfake, and that person would be a victim. So the approach I would take is each of the complainants would actually need to be part of a complaint to the police. That would make more sense. And if it were a civil case as well, I would say, and they would want to report to the information regulator, do a joint complaint form, because if you have multiple requests, it creates more work and more backlog for organizations that are already overwhelmed.
Yeah, true. Interesting. Wow. Okay. So, Nathan, where can our listeners reach you on social media or even your website? I know you have a fabulous website. If they want to reach out to you or ask you any questions about technology law, where can they find you?
Okay, awesome. So I'm usually, as you mentioned earlier, I'm usually very active on LinkedIn, probably post like 50 times a day, but that's the way I stay active in knowing what's actually happening in the world. But yeah, you can find me on LinkedIn. And my full name. I also have a blog website that hasn't been updated in a while, but you'll find some useful content there. It's called africantechlawyer.com. And then if you are interested in any legal services relating to IT law or AI law, you can find me on the michelsons.com website. And you'll be able to click under our people, and then my profile should be there with my direct contact details.
Fabulous. Thank you so much for joining us.
Thank you for having me.
Remember to control your image rights.